Equality under the Indian Constitution. How do we understand the right to equality? Does the Constitution guarantee equality in all circumstances? What are the protected grounds for non-discrimination under the Indian Constitution? This is what I'm going to be talking about today, and I'll be attempting to answer some of these questions in my talk. The Indian Constitution looks at fundamental rights in Chapter 3 or Part 3 of the Constitution, and the main articles that deal with equality are Article 14, Article 15, and Article 16. I'll try and give a broad understanding of how the Supreme Court has interpreted some of these articles so that we can get a better understanding of how the right to equality is understood and implemented. Article 14, that's what I'll start with. Article 14 guarantees equality before the law and equal protection of the law. So what do we mean by it? A very simple reading would say that everyone has equal protection before the law. And that, to some extent, can be understood as formal equality. Formal equality is kind of defined as the fact that likes be treated alike and unequals be treated differently. So two people in the same position should be treated alike, and people who are differently placed should not be treated alike or should be treated differently. That is what formal equality means. But our Constitution and the interpretation given to the right to equality under Article 14 by the Supreme Court has expanded or broadened the notion of equality to say that equality before the law does not just mean formal equality, because formal equality, even though it may seem to be equal, where you treat likes equally or different people differently, in many cases does not take into account what real equality on the ground would require. It would not take into account social and economic disadvantages that are present in our country, and for equality to be truly implemented, the concept of substantive equality has been articulated by the court. What does substantive or real equality mean? Under the concept of substantive equality, our courts have said that just because there is differentiation, that does not amount to discrimination. Different treatment in many cases is permitted, in fact, and is required to promote equality. If there is a reasonable nexus for such differential treatment, then differential treatment can also be a facet of equality. I would like to elaborate how substantive equality, or what really is the meaning of substantive equality in a more detailed way. Substantive equality, the goals of it are to ensure, there are multifold goals, and the goals of it are to ensure that we remove disadvantage. So people who are in disadvantageous positions, they should be able to we should be able to address that disadvantage and remove it. One of the goals of substantive equality is also to address stigma, stereotyping, and prejudice. We see that different groups of people, for example, women, people with disabilities, many different categories of people who are in disadvantaged positions face discrimination, stigma, and prejudice. And measures of substantive equality should be able to address the stigma and prejudice that they face. One of the goals of substantive equality is also to enhance participation. It could be participation in public life, participation in public employment, or participation in any other way, socially or publicly. And finally, the last aim of substantive equality is to accommodate differences. Differences should be accommodated and should be taken account of if we want to treat people equally and to ensure that they get an equal opportunity. So all of these measures go into the concept of substantive equality. And this is what our courts have understood equality to really mean. And I'd like to give a few examples of how substantive equality and some of these principles of substantive equality have been implemented. So, for example, the Supreme Court in some of the recent cases over the last 2 or 3 years, especially in cases of gender discrimination, have taken up the principle of stereotyping on the basis of sex or gender. And the example I'd like to give is in the case of Joseph Shine versus Union of India, where the offense of adultery was challenged and the section was held to be unconstitutional. Also in Navdeep Johar versus Union of India, where Section 377 was challenged. In both of these cases, the Supreme Court held that women face stereotyping as to their roles and what society expects of them. So in the adultery case, there was an expectation that there was a stereotyping of how women within marriage are understood to be, and similarly what gender roles are that are imposed by society was considered under the 377 challenge, and the court held that stereotyping on the basis of gender is also a form of discrimination under Article 15. And therefore, I think this is a very important argument where stereotyping has been taken up as a measure that our equality jurisprudence has to address. Finally, Article 14 goes on to hold that any kind of arbitrariness would also be a violation of the right to equality. So any arbitrary or unreasoned action taken by state would certainly amount to a violation of the guarantee to equality under Article 14. A further understanding of what equality means is, does equality require us to only ensure that someone is not treated unequally? Or does it also require us to require the state to take additional positive steps to ensure that someone is in fact treated equally? And in this case, the courts have actually held that equality is not just a negative right, it's also a positive right. So a negative right would be something that the court would ensure would restrain action that would discriminate against someone. But a positive right, and that is what the Supreme Court held with regard to Article 14. In the case of Amita versus Union of India, this was a case where the petitioner was a person with visual impairment, and she was not allowed to sit for an entrance exam for a job under the government on the grounds of her disability. And the court in that case held that the right to equality is not just a negative but also a positive right, which means that the state is under an obligation to take specific positive steps to ensure that a person is treated with equal respect and is provided equal rights and with equal dignity. And that was the understanding given by the court in directing that she be allowed to write the test. So this places strong obligations on the state to ensure that it actually takes positive steps to guarantee equality to people. Let's move on now to Article 15, which is another facet of equality. The right to non-discrimination. Article 15 in our Constitution guarantees non-discrimination to all persons on the grounds of religion, race, caste, sex, and place of birth. It also has certain other provisions which guarantee that no one on any of these grounds would be excluded from access to public wells, shops, restaurants, or any other places of public accommodation. Now, Article 15, or the right to non-discrimination, can be really understood as the other side of equality. Equality and non-discrimination go hand in hand. While we have the right to equality, equality requires that people are not discriminated, which is guaranteed under Article 15. Now, Article 15, is it a satisfactory article, or are there any grounds that are missing? Now, I would argue that when the Constitution was drafted, perhaps the grounds of religion, race, caste, sex, and place of birth were considered to be sufficient as protections against discrimination. But as we move on and we see that equality and the recognition of equality has expanded to require many other protected characteristics against which discrimination should not be allowed. And many of those are not included in Article 15. For example, disability is a ground that has not been included. We have recognized disability as a characteristic where people should be treated equally. We have a law, the Rights of Persons with Disabilities Act, which ensures that there should be no discrimination against a person on the basis of her disability. But unfortunately, Article 15 under our Constitution still does not include it. The manner in which Article 15 has been interpreted has been done quite broadly to ensure that there is no discrimination on any of the grounds mentioned. But would it mean, the language says only on grounds of religion, race, caste, sex, or place of birth. So the general interpretation that is understood is that if you are, can get protection against discrimination only on one of these grounds. But what happens if you are covered by two or more grounds? And that's what I would term intersectional discrimination. What if you're a Muslim woman, which covers not just the ground of religion, but also the ground of sex? And the discrimination that you face, not just as a woman and not just as Muslim, but as a Muslim woman, is often much greater or graver and than the discrimination faced by a non-Muslim woman or a Muslim male. Does Article 15 cover such a situation? Till now, this kind of intersectional discrimination wasn't addressed. But in one of our recent judgments in Navteej Johar versus Union of India, for the first time, Justice Chandrachud did mention that Article 15 should cover intersectionality and intersectional discrimination as well. So it now remains to be seen how such an interpretation is actually implemented. What the judgment of Navteej Johar also did was that it expanded the ground of sex to include other grounds within Article 15. And those grounds were the grounds of gender identity and sexual orientation. Sex under Article 15 was expanded by the Supreme Court to include transgender persons who face discrimination on the basis of their chosen gender identity, and also people with different sexual orientations who face discrimination on the ground of their chosen sexual orientation. And both these grounds were included under the ground of sex. So in a way, more grounds have been added by a broader interpretation under Article 15. But this still leaves us with many grounds that haven't been added and which can't be added by a broadened interpretation and would only require perhaps a constitutional amendment, such as disability or age or many other grounds. Another ground that was also included by a broader interpretation under sex was the ground of pregnancy as a ground for discrimination. In the Air India case, where air hostesses claimed discrimination on the basis of their pregnancy, the court held that yes, this was a ground of discrimination under the category of sex. So we see that Article 14 and 15 have been expanded rather broadly by our Supreme Court to give a more well-rounded and a broader definition of equality and non-discrimination. Another manner in which this has been expanded is also to expand the right against non-discrimination and the right to equality, not just by the state, but also by private actors. And this has been done in several cases. So, for example, the guidelines for prevention of sexual harassment in Visakhapatnam held that this would be applicable to private employers as well. And this means that private employers and workplaces have an obligation to ensure that women at work are treated with equality and dignity. And this was also actually implemented under the Right to Free and Compulsory Education Act, where private schools and private managements were under an obligation to take in children from disadvantaged backgrounds on the basis of equality and non-discrimination. So in some ways, our fundamental rights to equality have been expanded to cover the private sector as well. Finally, I will address the third aspect of equality, which is the right to equal opportunity. And equality of opportunity is addressed in Article 16 of our Constitution. And in some ways, Article 16 forms a third prong of the principle of equality, which is really seen as 14, 15, and 16. Article 16 addresses equality of opportunity in public employment. And what does that really mean? What it means is that people from all backgrounds should get an equal opportunity to compete for public employment. And this article has really put the concept of substantive equality in practice. Other provisions of Article 16 go on to provide for reservation and affirmative action. And affirmative action is seen as a way of ensuring substantive equality in practice. What affirmative action or reservation tries to do is that it tries to ensure that people from disadvantaged groups, from socially or economically disadvantaged backgrounds, are given equal opportunity to compete. And the only way this equal opportunity can be provided is by reservation or affirmative action. And this is done to really give a level playing field to people from weaker sections. So in this way, Article 16 provides equality of opportunity, which is a third aspect of the right to equality. I'd now like to give, therefore, a final overview of how we understand the right to equality. One broad way of understanding equality under our Constitution is to look at the 14, 15, and 16 connections. But there's also another different connection, which has been called the Golden Triangle of Equality, and that has been done in a few other cases by the Supreme Court. And this Golden Triangle is that of Article 14, 19, and 21. 14, of course, guarantees the right to equality. Article 19 guarantees fundamental freedoms, freedom of speech, movement, association, trade and profession, etc. And Article 21 guarantees the right to life, and all that encompasses life, and a life with dignity. And in many cases, the courts have held that this is a golden triangle where equality is and does include freedoms and does include dignity. So if we really want to give a broad and well-rounded understanding to what our right to equality means, it is not just the right to equality and non-discrimination and equality of opportunity, but it also means the equal right to fundamental freedoms and dignity, the right to life with dignity. And this, I think, further shows us how all our fundamental rights are so deeply interconnected. And because they are interconnected, we cannot think of one right without another. All these rights are deeply entrenched, and that is the only holistic way to understand the right to equality. The right to equality, or rather I should rephrase it, the principle of equality or the equality value has been held to be such a strong principle that it is considered to be one of the principles of the basic structure of our Constitution. Our courts have laid down many judgments where the basic structure or the basic features of our Constitution have been delineated, and the equality principle is actually one of the principles of the basic structure, which means that even if our Constitution is amended, the basic structures cannot be interfered with, and the equality principle is one such principle enshrined amongst all these articles. So therefore, finally, once we get such a broad understanding of equality under the Constitution, how do we go forward? Are we satisfied with this protection of the right to equality, or do we need something more? Our wonderful, some of our judgments and court decisions do give a very, very broad understanding of equality, and it's quite a robust protection of this right. But as I discussed earlier, Article 15 does exclude many grounds of equality. The way the interpretation, even to protection of the right to equality in the private sector, is provided by the courts is fairly limited. So, in conclusion, my final argument would really be that if we really want a robust interpretation and a robust implementation of equality in India, in addition to what is constitutionally protected, what we really need is we need a law on equality and non-discrimination. We need a separate legislation that guarantees equality, very similarly like what the Constitution does, but a law that includes many other grounds, and that would ensure that not just the state but the private sector is covered by it too. A law that provides remedies where discrimination is carried out or where equality is not provided, and forums for such remedies. Thank you.